Thank you, everybody, for being here. My name is Carolyn Wisniewski. Jen and I both work at SPCA Tampa Bay, and I'm really pleased to introduce um, Emma and Cooper's mom. Emma and Cooper are two orange cats, and they are rescues, right, Stephanie?
Yes, they are.
And Stephanie is the founder of Edwards Elder Law Firm and has specialized in law for seniors, veterans, and their families. And it's a boutique law firm, and they don't take on a lot of clients. They're really able to be super selective and really provide an extremely high level and customized point of service. But because they specialize in elder law, and we know that there have been a lot of questions around end of life planning and living wills, we figured, given this new climate, that we would try and continue with our presentation, which we had planned. When we planned it, it was going to be live and in person at our veterinary hospital in St. Pete, but we're pivoting and doing it on Zoom. So I'm really pleased to introduce Stephanie Edwards. And Stephanie, the floor is all yours.
Thank you. All right. So what we're going to talk about today is a little bit about what do we need to think about for our pets, both if we become incapacitated or if we pass away. Because for most of us who have pets, we know that they are valuable members of our family. But a lot of times it's hard because it's really difficult for us to think about becoming incapacitated. And even though we all know at some point we're going to pass away, it's not something that we wake up and go, oh, I want to plan for that today. A lot of times we forget that these types of events that have impacts on us will also have impacts on them. And they don't understand. All they understand is that their lifestyle has been interrupted. And if you are the parent of cats, you know that they do not like to have their schedule interrupted at all. So the more we can kind of think ahead about what could we do for them if these events happen, probably the more peace of mind for us, and the better able they're going to be able to cope with these changes. So the first thing that we talk about is what are the documents that you can put in place that will designate who's going to make decisions for you if you're alive but incapacitated. There's three documents. There's the healthcare surrogate, the living will, the durable power of attorney. Then we're going to turn our attention to the document that speaks for you once you pass away, which is the will. There's a trust, which we're going to speak about just briefly. It can do some of the jobs while you're alive and some of the jobs once you pass away. But and we have a handout that we can put up to show you that helps to kind of keep all of these documents in the right order for you, because a lot of them have similar names. So you'll see, oh, there it is, thank you. So you'll see in column number 1, the documents that speak for you while you're alive, but stop speaking for you once you pass away, are the healthcare surrogate, the living will, the durable power of attorney. And we'll come back in a minute and talk about each one of those. Over in column number 3, that's where we look at the documents that speak for you once you pass away, but they don't have any job to do for you while you're alive. That's the will. And then we've got the trust in the middle in column number 2, because it can do some of the jobs of the durable power of attorney, and it can do some of the jobs of the will. So let's start first with column number 1. You are alive but incapacitated. It could be a temporary incapacity. It could be a longer term incapacity. The healthcare surrogate is the person that you've designated to make healthcare decisions for you. It can be whoever you choose. Some people choose family members. Some family members say, I don't want to make the, oh, there we go, there's some family members. Some family members say, I don't want to make these types of decisions, but anything that falls in the world of making medical decisions for you falls to your healthcare surrogate. Now, if you have not put these documents in place, the healthcare surrogate, living will, durable power of attorney, it's not that you don't have a plan, it's that you have the state of Florida default plan. So if you haven't designated who's going to speak for you, the state of Florida has a default plan in which it says who's going to speak for you. For some people, that default plan works out just fine. For some people, that default plan is not at all the person that they would want to speak for them. So the default plan goes through a list. It's going to go look for a spouse. Then if your spouse is not available, it's going to drop down to your children. If you don't have children, it goes up to your parents. For most people, if they have a spouse, a lot of times they say, well, I'd want my spouse to speak for me anyway. It's always the just in case sort of option that can make things a little interesting, because if you and your spouse were in the same car accident, now it drops down to your children. And if you have more than one child, they all have equal capacity to make this decision for you and equal authority to make this decision for you. If they disagree, it's going to court. And then the judge is going to have to make the decision, break the tie between your children. So a lot of times, bringing your family together and saying, yes, I love all of you. I want you all to be involved, but I've designated these specific decision makers in this specific order using your healthcare surrogate document. It can really help to maintain some peace and maintain some order in what is always a very emotional and volatile situation. It also gives you a chance ahead of time to talk to the person that you've chosen and say, this is my idea of quality of life. These are the types of decisions I would want made in these types of medical situations, because it's very difficult to find out right in the middle of a health crisis that you are the person who's been designated to speak for someone, and you have no idea what they would want. And it's further complicated because they're a family member that you love. So this healthcare surrogate gives you the opportunity to say, this is who I want to speak for me. If this person was in the same car accident with me, this is the next person I want to speak for me for medical situations, and on down the line. You can list as many people as you would like. A subset of the healthcare surrogate is the living will. The living will's only job is to say that you do or you don't want to be kept alive artificially, so that when the doctor asks your healthcare surrogate, okay, if we need to put your loved one on, for example, the breathing machine, not to help them recover, but they're never coming off, is that something they want, or is that something that they don't want? So the living will's only job is to answer that question, so that then your healthcare surrogate will know the answer. Another reason to kind of talk to your healthcare surrogate ahead of time, or not to have to rely on the state of Florida default plan, because it can be really overwhelming to, one, find out right in the middle of the crisis that you're the healthcare surrogate, and then two, find out that you have to answer this life or death question for someone, and you don't know what the answer is. So that's how it works in the medical world. You've got the healthcare surrogate and the living will. That doesn't impact our pets as much as when we talk about the durable power of attorney in a moment. But before we leave the healthcare surrogate and the living will, let's just pause for a moment and see if there's any questions about this document that works in the medical world for you.
So Stephanie, I have not seen any questions come into the chat field yet, but I have
Okay.
put a reminder up that people can enter their questions and you will pause to take them throughout the presentation.
Okay, perfect.
Thanks.
So let's talk about the durable power of attorney, because that's the one that has more of an impact on our pets. So medical decisions made by the healthcare surrogate, any other decision that needs to be made for you while you're alive but unable to make your own decisions is going to be made by the durable power of attorney. This is going to be who's going to pay your bills for you, who's going to take care of your health for you, who's going to take care of your pets for you. What's the plan for the pets? Are you able to have your pets stay in your home because you've got a pet sitter or another trusted family member or friend who's coming in to talk to your pets, take care of your pets? Are your pets going to need to be boarded? These types of decisions don't have to be stated in your durable power of attorney document, but it is a conversation that you're going to want to have with whoever you designate as your durable power of attorney, so that they will know what are your wishes, not only for yourself, but what are your wishes for your pets? How would you like to have them cared for? Who's your pet's vet? Which food goes with which pet? I mean, I have 2 cats. They eat entirely different cans of food. Cooper has one thing that he will eat, and that is the only thing, and only if it's a fresh can every day. So if he accidentally gets Emma's food, he's not going to eat, and then that's going to create even more stress for your person who is taking care of them. So the durable power of attorney is the person who, among everything else that's non-medical related, is going to be charged with making sure that your pets are being taken care of. Now, there's also a default plan for the durable power of attorney if you haven't put one in place. It's an entirely different default plan than on the medical side. With the healthcare surrogate, if you haven't filled out your healthcare surrogate form and designated your spokesperson, it's going through that list of family members that we talked about. With the durable power of attorney, it does not go through a list of family members. It goes straight to guardianship court. That's the default option, is that everybody, including your family members, need to go to guardianship court and petition to become your guardian. So another emotional kind of disruption in the midst of an already emotional situation. So putting your durable power of attorney in place can be really important in knowing that the person you've chosen is going to make these important decisions for you, including making sure that your pets are taken care of. Now, there's 2 things to know with this durable power of attorney. The first one is that it has to be somebody that you trust completely, because they really are you. They can do anything that you can do, including taking all the money out of your bank account and taking a vacation to Tahiti, should they choose. So it has to be somebody that you trust. The other thing to know about the durable power of attorney is the law in Florida changed dramatically in October of 2011. So if you put this durable power of attorney document in place before 2011, and you're thinking, oh my gosh, great, I don't have to go to guardianship court. I was organized, I took action, I put my durable power of attorney in place. Well, now the law has up and changed on you, and your durable power of attorney pre-October 2011 is still valid, but it does not work for you as well as it did previously, because before October 2011, it was a nice short little document in which we kind of got to say, this person can be me, they can do anything I can do. And maybe we listed, take care of my bank account, take care of my pets, but didn't matter what we listed because we had this nice general paragraph that said, they're me, they can do anything I can do. The big change in the law was that general paragraph that said, they're me, they can do anything I can do, went away. And now everything has to be listed out specifically. And there are about 15 things that also have to be initialed. And if they're not listed out specifically and they're not initialed, your agent can't perform those activities on your behalf. So anybody who has a durable power of attorney pre-October 2011, it's kind of like it's finally gotten cold in Florida and you pull the blanket out of the closet and you open it up and the moths have eaten holes in it. It's still there, but it's not going to keep you as warm as it did when there were no holes in it. That's kind of what's happened to the durable powers of attorney pre-October 2011. So definitely you want to get that updated. The other question that comes up with all three of these documents of who's going to speak for me if I become incapacitated while I'm alive is actually the answer to that question. Who do I want to choose? Who is the person that I want to put in charge? And it's very interesting to me because I'll have a lot of parents in my office and they want to name each other first. They want to name their spouse first. But then when it comes to the children, they have multiple children, and invariably they'll look at me and they'll say, I don't want my kids to fight, because really that is the top priority for any parent, whether they're talking about incapacity or passing away. I don't want my children to fight. So because I don't want my children to fight, I'm going to name the oldest. That's who I'm going to choose. And I am an oldest child, so I feel that I can share with you that as oldest children, we spend our whole lives trying to tell you that we do everything better than our siblings do because we did it first. So therefore, we must have done it better. But as an adult oldest child, I have had to come to the same sort of realization as any oldest child has to come to, that might not be the case. We might not be the best choice for every job. So you want to kind of match the person that you choose to the job. The person who might do best in the medical environment in chasing the doctor down the hall and saying, yeah, you can't leave, we still have questions, might not be the same person who is going to be best at taking care of your bank account and making sure your house is taken care of and making sure your pets are taken care of. So kind of match the person to the job, and then chat with your family and say, okay, again, it's not that I don't want you all to be involved in making sure that I'm okay and making sure that all these things are taken care of, but these are the decisions I've made about who's going to be the spokesperson, who's going to be the decision maker, and why. And then that's kind of really the best thing you can do to kind of make sure that these things are going to work and in as smooth a manner as possible in kind of an emotional unknown situation. Okay, so before we then jump over to, oh my gosh, now you've passed away, anybody have any questions about either the medical, the healthcare surrogate, living will, or the everything else durable power of attorney?
Stephanie, I think you are just presenting this information so clearly. We have not seen any questions come in yet, but just a reminder, if you do have a question, use that chat box and we'll make sure that we present it to Stephanie. So I would say forge ahead.
Okay, off we go. Oh wait, I see a question. So the question says, do you need a lawyer to get a durable power of attorney? Oh, this is the favorite question for the lawyers to answer because it's so hard for us to answer this without sounding self-serving. But I'll tell you the experiences that I've seen with my clients and why that leads me to say yes, you probably want to get an attorney involved, not because I am an attorney, but just because I can tell you what happens. Because the default option with the durable power of attorney is if it doesn't work or you've missed something that you need, the only default option is that you have to go to guardianship court. So maybe you forgot to initial one of the boxes, or you didn't realize that you needed to initial the box. And that was the box that we needed to set up a trust for you. That's one of the things that has to be initial. If it's not initial, and the best way to take care of you is for the durable power of attorney to set up a trust for you, now the durable power of attorney has to go to guardianship court, petition to be appointed your guardian, and then ask the court for permission to set up the trust for you. So 30 seconds in guardianship court is more expensive than the entire experience of using an attorney to put the durable power of attorney in place for you. So it's really, because Florida is so picky about their durable powers of attorney, and everything has to be listed out specifically and certain things have to be initialed, I usually tell people it is well worth the investment to have the attorney help you, because the consequences of not having it done correctly are you got to go to guardianship court. And the guardians are wonderful people and they take their job seriously, but that's an expense that you probably didn't have to incur if you had been able to invest in having the attorney help you from the beginning. So that's my attorney answer to that question. So, okay. I see another one. What do we do if we don't have any kids around to take care of our cats? Oh, then I can see Ken 1, but I can't see the rest.
Stephanie, it says, can one of our neighbors or friends help if both my husband and I die at the same time?
Okay, oh, die. So we'll get to die in a second. Hang on to that question about dying. But if that was the same issue while you were alive, if both you and your husband were in the hospital at the same time, you want to talk to the person who you've designated as your durable power of attorney, the one who's going to make decisions for everything other than medical decisions, and say, hey, my neighbor knows my cats. My neighbor is who I really want you to be able to turn to assist with my cats. Now, the neighbor doesn't need the durable power of attorney's permission to do that, but you want to kind of coordinate it, because otherwise the durable power of attorney is going, who's in the house? You know, who's taking care of the cats? They don't realize that you've got a plan. So whoever you name as the durable power of attorney, coordinate with them and say, look, this is the person that I would like for you to work with to take care of my pets. I don't know if that answers the question. All right. I don't see any other ones. Jen, do you see any other ones?
No, it looks like those were the only two that came in, but feel free to continue entering questions into that chat box, please.
Okay, so now we're going to jump over to you've passed away. And once you've passed away, now your healthcare surrogate, living will, durable power of attorney, they don't speak for you any longer. Those people are not in charge anymore. Those documents can't speak for you. Now we jump over to column number 3 and we look at your will. And that is where we are going to get the instructions about who you want to speak for you once you pass away, and the instructions about who do you want to inherit your pets? Would you like your pets inherited? Would you like to give them kind of, we call it a dowry? Would you like to set aside a certain amount of money to help the new owner with integrating the pets into their family? The question comes up that we just had, you know, what happens if I pass away and I don't really have anybody that I want to, that I can name to take in my pets or take care of my pets? And part of that answer, I'll give you a little cliffhanger. You know, part of that answer is going to come up when Carolyn and Jen tell you a little bit about the SPCA's pet trust, because in a lot of ways, the pet trust was created for just these types of situations where we don't have a nice, smooth answer of, okay, my spouse is still alive, he or she's going to take care of my pets, or I have children that live really close by, so I don't have to worry about who's going to take care of my pets while my child travels from Michigan to Florida to take care of my pet. Or I don't really know who's going to inherit my pet. How do I make sure that they're going to get adopted in a a way that's good for them and makes this whole trauma much less traumatic for them? It's a real issue of who's going to take care of my pets, if they outlive me. And a lot of those instructions can come in the will, and we've got some other options, which we'll talk about momentarily, about some other options you might have for taking care of the pets. During incapacity, it's really friends, family members, stepping in and taking care of your pets. Those temporary incapacities are a little bit more difficult for organizations to step in and help take care of the pets. That really takes a lot of talking to the friends and neighbors. We do have some options through the SPCA Pet Trust to help with helping to rehome your pets once you pass away. So the document that talks about most of your instructions about what you want to happen to pass away is going to be the will. Now, not everything you own is going to get instructions from your will. For example, a life insurance policy in which you filled out a beneficiary form, whether that be a paper form. I don't even know if they still have paper forms that we fill out. Everything's online these days, but basically the equivalent of filling out a form saying, I want my life insurance policy to go to Sally, and it in essence gets stapled to your life insurance policy, whether that's in person or virtually. That beneficiary form is going to give instructions as to where that life insurance policy money is going to go, not your will. So anything that has a beneficiary designation is not going to get instructions from your will. Anything that you own jointly with another person with built-in survivorship rights. So just because you own something jointly with someone doesn't mean there are built-in survivorship rights. If you are a married couple, typically, yes, there's going to be built-in survivorship rights. So if you own the house with your spouse and you both own it, typically there are the unwritten legal rule is your spouse automatically owns it. We don't get instructions from the will because there are built-in rights of survivorship, kind of like a contract. If you own your house jointly with your sibling, there may or may not be built-in rights of survivorship. It depends upon what language was put in the deed when you bought the property. But if there are built-in rights of survivorship, that asset's not going to get instructions from your will. Typically one that happens, and we just had this happen the other day in the office, is sometimes people, your spouse is predeceased you, trying to do emergency type planning. You say, I'm going to put one of my children on my bank account with me. I'm going to make them the joint owner so that they can step in and they can pay bills, etc. And your will says, I want everything I own to be divided between my 3 children. But this bank account that you own jointly with this one child, it's usually got built-in rights of survivorship. So when you pass away, that bank account that you own jointly with your child is not going to get instructions from your will that says split it 3 ways. It's got built-in survivorship. It's going to that one child. It's going to be up to that child as to whether they're going to honor your wishes and split it 3 ways, or whether they're going to say, yeah, bye, going to Tahiti, see y'all later. Your durable power of attorney can step in and take care of your bank account, So a lot of times it's a better idea to not put one of the children on the bank account as a joint owner, but to let your durable power of attorney step in. So your will gives instructions to your assets that don't have any other instructions. They don't have a beneficiary form attached to them. They aren't owned jointly with somebody who has survivorship, or they aren't living in the trust, which is why we talk about the trust last. So the will gives instructions for anything you own in your own name, no beneficiary, no joint owner, not living in your trust bucket. That's definitely your pets. Your pets are pets, although we consider them family, they are considered property under the law. So they are going to get instructions from your will as to what you want to happen to them, who you might want to inherit them, any types of instructions you want to give as to how they're going to be taken care of. So that's what the will does, speaks for you once you pass away, for anything you own that doesn't have any other types of built-in instructions, like a beneficiary or a joint owner with survivorship, or the trust. And we're going to talk about the trust for just a few minutes in a moment, but any questions about the will before we go to the trust? That's our last thing to cover before we get to hear about the pet trust.
So nothing has come in yet, but if we pause for just a moment in case anybody has a burning question to type into that chat box. I know the last two came in right after one another. So I'm not seeing anything yet, Stephanie.
Okay, so let's talk about the trust for a minute. So the trust was in the middle of our chart because, as I was saying, the trust can do some of the things that the durable power of attorney can do, and it can do some of the things that the will can do. When you think about a trust, think about a bucket. Like I tell people, think about the little kids running around on the beach with their little sand pails. It's like they're all running around with little trust buckets, because that's all a trust is. It's a bucket. And if it's your trust, it's a bucket that you're running around the beach carrying, and you can put anything you want in that bucket. If we tip the bucket over and everything comes out of the bucket, it still belongs to you. It's just that we've moved it over into the bucket. So instead of, living in your, think about, let's say you have a bank account. Instead of having that bank account get instructions from your will, we move that bank account, think of it like a block and a bucket. We put that block in the bucket. That what the attorneys also put in that bucket with the block, that for example can be your bank account, are what are in essence babysitter instructions. All that paper that you come out of from the attorney's office when you have a trust, all that official looking paper, it's basically glorified babysitter instructions, because it says, if I can't take care of my bucket, my trust bucket, this is who's going to take care of it. If I'm incapacitated, this is what you're allowed to use, anything that I've put in my bucket to pay for. And if I pass away, this is who I want to inherit what's in my bucket, and this is how I want them to inherit it. So anything any asset that you own, in our example, your bank account, that you have moved over to the trust bucket, it gets instructions from the trust bucket babysitter instructions. So it's got built-in instructions, which is why it doesn't have to get instructions from your will. So trust bucket has its own instructions, follows those instructions, no instructions from the will. Life insurance policy that you named a beneficiary for gets instructions from that beneficiary form, no instructions from the will. Bank account that you own jointly with your spouse, if you're the first person to pass away, built-in instruction is it goes to your spouse. The will picks up everything else, anything you own in your own name that has no other built-in instructions, that doesn't know where to go without these instructions from the will. So that's how everything kind of breaks down. And so the will is definitely where we look in order to get any instructions that you want to leave regarding your pets. Because as much as the cats might think it would be fun to jump into the trust bucket, you have to think it's not big enough for them. So we're not allowed to move the pets into the trust bucket. They're going to get instructions from the will. So, okay. And anything else before I then turn it over to Carolyn and Jen?
So Stephanie, I'm not seeing any questions that have come in based on what you just presented. Let's give it a moment. Okay, not seeing anything.
All right, then now we can go on to the pet trust, which I will turn back over to y'all.
Very good. Thank you, Stephanie. Thank you so much. That was a lot of information to share, and you did it right on cue. I think we talked about handing it over right about this time. So my name is Jennifer Gross. I am the Director of Philanthropy with SPCA Tampa Bay, and I just want to again thank everybody for joining us today for the session on estate planning and pet trust planning. So what I want to talk a little bit about is our Legacy of Love pooled or communal pet trust through SPCA Tampa Bay. So I'm just going to bring something up quickly. There you go. You should be seeing the top part of our Legacy of Love communal pet trust brochure. So our communal pet trust is different than a standard trust because multiple pet owners fund accounts within one pooled trust. It offers a great way for pet owners to plan for the care of their pet after they pass away. So here's how it works. The pet owner would let us know that they'd like to fund a pooled pet trust account with us. And then what they will do is complete a pet profile form. That gives the owner an opportunity to tell us everything about their pet, from behaviors to veterinary issues, anything that would be relevant for the new owner. They'd also, in that pet profile, let us know if they'd like to name a specific guardian for the pet, or if the pet would come to us at SPCA Tampa Bay and go through our adoption process. So I just for a moment want to show you what the pet profile form looks like. If I can, no, I'm sorry, I thought I had it pulled up. I do not, so we'll go back to this visual. So once that pet profile form is done, the pet owner would also complete a pet trust pledge agreement and a simple legal joinder form to enroll in our Legacy of Love communal pet trust. There is a $250 administrative fee to set up the trust account, and we do ask that a minimum initial funding of $1,000 is made to set up each trust account. So that $1,000 is a 100% tax deductible donation made to SPCA Tampa Bay during the pet owner's lifetime. And what happens with those funds is they'll be held to care for the pet after the owner passes away. And it ensures that some funds are available to either us at SPCA Tampa Bay or to the new pet guardian before the estate is settled. And then what happens once the estate is settled, funds in the trust account will be available to us and to the pet's new owner on a reimbursement basis to cover the cost of the pet's veterinary care. So then what happens when the pet passes away, any funds remaining in the pet trust account will come to SPCA as a donation to support programs that care for animals and the people who love them. So Any questions? There are two questions that we hear often, but I want to pause for a moment and see if anybody has specific questions to what I've just shared. Okay, don't see anything coming in. One question that we do hear about the pooled pet trust is, what happens if my pet dies before I do? So in that case, if you have set up a communal pet trust or a pooled pet trust account with us, and that pet passes away before you do, you can then, if you adopt a new pet, you can complete a new pet profile form sharing all the same information, behavior issues, veterinary issues, how you would like that new pet to be cared for once you've passed. And you can submit that new pet profile form to us. Then what we would do is transfer that trust fund account over to that new pet. Another question we do hear is, how much money do I need to set aside to fund one of these pooled pet trust accounts? So as I mentioned, we do request that $1,000 initial funding during the pet owner's lifetime. The remainder of that trust account would then be funded by the pet owner's estate. And we do ask for a minimum of $10,000 total in those communal pet trust accounts. But that amount can certainly be higher if the pet owner chooses to set aside more funds for the care of the pet. So I see one question that has come in. Marta is asking, what if I don't get another pet? So if the pet passes away and you don't get another pet, that money then upon your death would come to us as a donation to help fund programs, again, for animals and people who love them that are run by the SPCA. So I hope that answers the question, Marta. Any other questions? Okay, so just kind of wrapping up, more information is available on our website about our Legacy of Love Pooled Pet Trust, and I certainly invite you to call me or email me. Carolyn, I would say the same. We're here to answer your questions, so if you think of something that that you did not ask during today's session, please reach out to one of us, or if you're ready to set up a Legacy of Love communal pet trust account for your pet, we're here to help. So Carolyn, do you have anything to add?
I don't. We had committed to being here till 2, so if people are interested, we can take you off mute, and we're more than happy to actually answer questions over voice if that's easier for some folks. Stephanie will be here. We can stay on until 2 and just answer any questions you have. Happy to do that.
Perfect. So I'm going to unmute everybody. Just a warning, if you have background noise on your end, you might be able to mute yourself. So the line is open.
You've answered all my questions, so I really appreciate learning about the Legacy Trust and about the fact I'm still missing some things I need to do. So I really, really appreciate this.
Okay, I do see one question that says, do I have to say the type of person I would want to adopt my pet? Jen, do you want to take that or should I?
So in that pet profile form, I'm happy to start. Carolyn, I'll let you add anything. That pet profile form, we certainly want you to share any information about your pet with us. So for instance, if that pet has lived in a home with children or has not lived in a home with children, lived in a home with cats or dogs, you know, any fears, anything relevant to that pet, we certainly want to know that information so we can pass that along to potential adopters.
So I guess what I would take that a step further and say that what if, as part of the pet trust, you don't have somebody already picked out to take care of your animal, then the animal will get the animal, provide medical care, whatever medical care that they need, and then put the animal through our regular adoption process. And that adoption process, we call it our matchmaker process. And our animal welfare associates really love that part because they get a chance to ask adopters what kind of animal they're looking for, what kind of lifestyle they have, so they can really have a chance to make a good match between the potential adopter and the animal. So we do our best to make that really a good fit, but we don't really have the ability to allow somebody to make those really narrow specifications with this trust. Great question.
Anyone else? And everybody is off mute, so if you want to speak up and not type in, now's your chance.
I have a question. Is this program in place with SPCA countrywide or just in this area?
So this particular communal pet trust is unique to SPCA Tampa Bay. If you're looking at other SPCAs throughout the country, you might want to research whether they have a similar program, but this particular pet trust is unique to us.
And part of the reason for that is SPCAs are not all one national organization. We're all incorporated locally in our local communities. So SPCA is our own profit organization, and we're not limited to other nonprofits.
Right. Thank you.
But I will say the other thing to keep in mind is that part of the reason we saw the need for this is that Florida does consider pets property, right, Stephanie? And that might not apply in other states.
I don't know about other states, but I will say in trying to help people put plans together for their pets, this concept of a pooled pet trust is it's really a wonderful solution, because if you try to set up a pet trust on your own, there are so many people that have to be involved. I mean, it's hard enough sometimes to say, who's going to take care of my pet? But if you set up your own pet trust, you have to say, who's going to take care of my pet? A different person then takes care of the money. A different person runs the trust. And by the time you try to set this up, you've got all these people involved that are really difficult to identify. And what if one of them passes away before you? Now you're coming and redoing everything. So to have this ability to join an existing trust, and all you have to worry about is, one, if you do know who you want as your first choice to inherit your pet, absolutely, you get to say, this is who I want to be my pet's caregiver. But if something happens to that caregiver and you don't have a backup, you know the pet's not going to fall through the cracks. They're not going to accidentally wander out the door because all the family members are running around and they get lost, or you're not going to have to worry about any sort of gap in treatment for them, because nobody knows who's going to take care of this pet. So this is such a wonderful solution, because there are so many safety nets built into it to help make sure that what we all fear the most for our pets, that they get lost in the shuffle of this highly emotional situation, doesn't happen. And so that's what's so comforting about it, and what kind of makes it such a unique and wonderful option for so many people.
I have a question. Can you hear me?
Yes.
So I think I understand you want $10,000 per pet into their trust. And then the SPCA is keeping that money through the remaining life of that pet, and the person who adopts my pet then submits vet receipts or something for reimbursement? Is that how it works? And it's only for vet care, not like food and stuff like that?
So that is correct. It would be on a reimbursement basis, and we would rely on that new pet owner to submit those receipts to us for reimbursement. We are focusing on veterinary care for the pet, simply because those are really the largest bills that are coming in. So really veterinary care would be the focus of that.
And
Okay, and
go ahead.
can they go to a vet of their choice, or do they need to go to the SPCA vet?
No, so they could continue, the pet could be taken to the veterinarian that the owner was taking it to. That's why on our pet profile form, we do ask for the veterinarian information. So yes, they could go to their chosen vet. Carolyn, you were going to say something?
I was just going to comment in general that the pet trust is a really good option for senior pets as well, because it's the medical care that can get really expensive for an adopter and can sometimes be a barrier to adoption.
Mm-hmm.
So it works out well for senior pets.
Great. We have a couple more minutes on the line. Any final questions before we wrap up?
Okay, yeah, sorry, I have one more question.
That's okay.
Because we are residents here in Florida and we spend most of our time in Florida, but we do go to a different state in the summer. So if we would happen to, you know, die not in Florida, then I guess we would have to tell our durable power of attorney that they would need to get in touch with you guys here in Florida and make our, you know, transport our pets back here. Is that how that would work?
Stephanie, can I ask?
Oh, yes. So it doesn't matter. It doesn't matter who's gonna make the arrangements. You know, technically the durable power of attorney loses their ability to speak for you once you pass away. However, they are probably the person who's most aware of what this plan is. So I would say you want to make sure that your durable power of attorney knows that you have this pet trust set up, and you want to make sure that the executor of your will, Florida calls it the personal representative, knows that you have this pet trust set up. Because in the will, we like to try to include a provision that says, look, if there's any costs that have to be incurred in transporting the pet from where the pet is to where the pet needs to go, that will be paid for from the assets in the will. So I would say don't worry so much about the technicalities of who needs to make sure the pet gets there. Make sure that your family members, just make sure that anyone who might be involved in this process knows that you have this account with the SPCA, because it's kind of the same thing as life insurance. There's not a directory. So there's not like there's a directory somewhere where you get to look up and say, where does someone have a pet trust or where does someone have life insurance? If your family members don't know, then it doesn't happen. So definitely make sure that the people around you know that this is what you've chosen, so that they can call the SPCA, and then mutually y'all can kind of figure out how the pet's going to get to the SPCA. Or if the pet's not going to the SPCA, the pet's going to the new owner, and you've put those arrangements in place, there's still that notification process to the SPCA so that the new owner can start the reimbursement process. Anything that y'all would want to add, Jen or Carolyn?
No, that covers it. Thank you for jumping in and again mentioning the difference between the personal representative and the durable power of attorney. That helps.
I know they all run together. That's what we start, because you're like, oh, could they sound any more alike?
Right. Did that answer the question okay?
Yes, thank you very much.
Okay. Okay, we're here for 5 more minutes. We've got the line for 5 more minutes. So if anything else is out there, everybody's still off mute.
Hi, Candy. Thank you. You're welcome.
Hi, Candy.
Thank you, everybody, for joining us. Jen, your email and phone number are in the confirmation email that everybody received, correct?
Correct. And I will be following up with an email later today to everyone who attended that has a couple of resources on the PDF that was shared while Stephanie was speaking. My contact information is also there, and as well as a link to more information about our communal pet trust online. So I think that will do it. Any last words, Carolyn, Stephanie?
No, thank you for spending part of your afternoon with us.
Yes. Thank you everybody for being here, and we appreciate you learning more with us. We hope everybody stays safe and healthy and enjoys the rest of their Sunday afternoon. Take care.
Bye.
Thank you.
Bye.
Thank you, everybody.